Judgment in the appeal of Oceanbulk Shipping and Trading SA against TMT Asia Limited.
Lord Clarke will deliver the judgment.
This appeal concerns the scope of the exceptions to the without prejudice rule. That is, the rule that statements made in the course of without prejudice negotiations are not admissible in evidence. The issue is whether it is permissible to refer to anything written or said in the course of without prejudice negotiations to help interpret any agreement which results from the negotiations. The parties to a number of forward freight agreements, or FFAs, were in dispute as to the sums due under them. They entered into settlement negotiations which were expressed to be without prejudice. The negotiations resulted in a written settlement agreement in respect of the sum due. The respondent brought a claim for damages against the appellants, alleging breach of a clause of the settlement agreement. In their defence, the appellants sought to rely on statements made during the without prejudice negotiations in support of their interpretation of the clause. The respondent contended that reliance on the statements was precluded by the without prejudice rule. The judge, at first instance, held that the evidence derived from the without prejudice negotiations was admissible for the purpose of determining how the terms of the settlement agreement were to be construed, notwithstanding the rule. The majority of the Court of Appeal, however, allowed an appeal, holding the evidence was not admissible. This court has unanimously allowed the appeal. I gave the substantive judgment with which other members of the court agreed. The judgment discusses the without prejudice rule and its exceptions in some detail. It stresses the importance of the rule, which is partly based on the public policy of encouraging parties to settle their difficulties. However, it recognises that there are a number of exceptions to the rule which have been held to exist where the justice of the case requires it. The judgment gives detailed reasons for holding that justice requires that there should be an exception in this kind of case. In particular, no sensible distinction can be drawn between this class of case and others where exceptions would be recognised, notably the case of rectification. The substance of the case is succinctly put in the one-paragraph judgment of the President, Lord Phillips. He is first kind enough to agree with my reasoning and conclusions, but adds this, quote, "The principle to be derived from this appeal can be shortly stated. When construing a contract between two parties, evidence of facts within their common knowledge is admissible where those facts have a bearing on the meaning that should be given to the words of the contract. This is so even where the knowledge of those facts is conveyed by one party to the other in the course of negotiations that are conducted without prejudice. This principle applies both in the case of a contract that results from the without prejudice negotiations and in the case of any other subsequent contract concluded between the same parties. Accordingly, the court orders that the appeal be allowed. We understand that the parties have resolved perhaps the whole case, but at any rate the issue of costs in this appeal, so there's no order as to costs."